Good morning, everybody. Hope you guys are doing well. For those of you guys who don't know who I am, I have a lot of clients of John Hart here this morning. For those of you guys who don't know who I am, my name is Harut Kerolian. I'm the broker, CEO, and founder of John Hart Real Estate. And this morning, I'm proud to have a conversation with a gentleman that I think that all of you guys will find that has a wealth of knowledge, wealth of experience, someone I'm excited to talk about. Last Wednesday, as a matter of fact, for all the John Hart agents, we did do a training on some of the rules and the changes that we've had to learn, study, adapt to in California pertaining to landlord and tenant rights. And this morning, my mission is to answer all the questions that weren't answered during last week's training with my agents, and any questions that you as our clients have. I'm honored to spend the next hour and 15 minutes with all of you. There will be follow-up questions. I can just imagine how many questions are going to come up over this next hour and 15 minutes. I've got at least 20, 25 questions prepared. And if every single question that Ray is going to answer is going to take a couple minutes, and then plus in addition, your follow-up questions, I can just imagine we can just be here all day. So I am going to not just try to get to my questions, but I am going to also try to get to your questions. Your questions and my questions will probably be similar because I do have most of the subjects covered. You might have a follow-up question at the end that I didn't ask, and I'll try to get to it. We are going to also publish this meeting later on as well, just in case you needed a recap or something you might have missed. So I am going to publish it. That doesn't mean that you log off, because chances of you going back and watching something that's not live is slim to none. So I definitely encourage all of you guys to pay attention to everything we're going to going over today. I do want to start out with something that I'm not going to ask Ray about. It's not pertaining to evictions or tenant rights, but there has been a little bit of uncertainty as far as fair market value in today's environment. So this is an opportunity that I want to take and make sure that all landlords, specifically who own homes in California, really understand the price gouging rules that our state has basically told us that we have to adhere to. So for those of you guys who don't know the website that you need to visit, so our clients that don't know the website that you need to visit, ask your agent. John Hart agents know all about it, but it is the HUD user website. It's pretty easy, basically to Google. You do want to make sure that every single one of you are making sure that you are looking at exactly the zip code that your home is in, and then finding out exactly what the value of that property is as far as what you can charge for rent. Okay. So if whatever the fair market value is on the HUD website, that's 160% of that is the maximum that you can charge. There's one caveat, and again, if you do have a home that you want to lease out, it's 160% of what HUD says. That's the maximum. So even if you have a home in Beverly Hills that's 4 bedrooms, 6,000 square feet, valued at $10 million, the maximum that you can charge for rental for right now until July 1st is right around $10,000. So definitely connect with one of our agents to make sure that you're given the exact amount. You don't want to break the law. It is the law right now until July 1st. So breaking it is there's also all sorts of punishments. So I definitely wanted to take this opportunity to make sure that all of you guys truly understand exactly what it is that it is required. So I'm going to now invite our special guest, Mr. Ray Hovsepian. Ray, Good morning, my friend. How are you?
Good morning. How are you doing, Harut?
I'm doing amazing. Thank you very much for this opportunity, Ray. There's so many questions, as you can imagine, right now with housing, rentals, tenant rights, landlord rights, and everything else in between. I'm sure that you're a very busy man and high in demand. So we all appreciate. I appreciate your time this morning. I know as an attorney, you charge by the hour, and this is very generous of you to give us your time and these 170 people and change that we have listening this morning. I know that they're going to have a lot of questions. I'm going to have obviously a bunch of questions. But before I start, would you mind just introducing yourself and telling us the Cliff Notes version of who Mr. Raymond Hovsepian is, please?
Thank you, Harut. First of all, I want to thank you, and I want to thank all of the agents at John Hart. I know many of your agents, very dedicated individuals, very professional offices. So it's really an honor for me to be here with the agents, with your clients, and try to answer as many questions as possible. It is a very uncertain field.
Mhm.
Um, I've been doing this almost 30 years now. June will be 30 years,
Mhm.
primarily in the area of landlord tenant law. I did other areas as well, but then I would say the last 5 or 6 years, I've been almost all exclusively in landlord tenant law because I think COVID really changed things a lot,
Yeah.
and high housing demand changed the laws a lot. So I've been only doing landlord tenant law, and there is a huge demand for it at this time, as there should be.
Yeah, absolutely. And it goes without saying that one mistake, one I that's not dotted, T that's not crossed, especially right now, with how backed up the courts are, judges are just basically kicking them out. So that's where I want to start, if you don't mind.
Not at all.
Is this getting any better? Are courts finding an efficient way of how to handle some of these cases? Or is this still archaic, still old school?
So let me tell you what happened. For the last, I would say, decade plus, maybe 15, 20 years,
Mhm.
there was a shortage of housing. There is a shortage of housing now because for the last 15 or 20 years, not enough housing was built. And as people were coming in, they were fighting over very scarce resources.
Yeah.
So it sort of got into a crisis mode, I would say, the last 5 or 6 years. And COVID obviously didn't help, but there was this fight over this very finite resource, and of course, politics got involved because people started to call their city council people and assemblymen and state senators on a local level,
Mhm.
and they start demanding that they not be either rents not be raised, or they wanted to have certain rights, at the expense of property owners.
Mhm.
And the political winds shifted towards that end because, after all, I would say 70 to 75% of the population in LA County are renters.
Yeah.
And, where are the votes going to come from? Where's the money going to come from? From renters.
Yeah.
So there was a shift. At the court level, there has been a huge shift in giving tenants free legal help. So there are lawyers, tax supported or nonprofits, who represent tenants. Landlords don't have that right. Landlords have to pay out of pocket. And so there is a glut of cases that are bottlenecked in the courts, and the case is not moving along. We try our best, but the law as written on paper is one thing, and then when you go and try to um, put those laws into action in the courts is another thing, because there is a huge bottleneck and cases are not moving very fast at this point.
That comes to me with exactly what I didn't want is happening already. I'm going off on tangents on the questions that I have prepared for you, but one question comes to mind as someone who's experiencing, as a matter of fact, tomorrow. I've got something at Stanley Musk, one of our buildings. It has to the tenant has requested a jury trial. Okay.
Yes,
So, can you explain to me and for the people that are listening, how a tenant can ask for a jury trial and what is the difference between a jury trial and a bench trial when it comes to eviction?
absolutely. So all eviction cases are civil cases.
Hmm.
And by the Constitution of both California and the United States, jury trials are constitutional rights. So every tenant,
Hmm.
just like a regular civil case, suing someone on a contract or suing someone because you were injured, you demand a jury trial, and each side can demand it. Now, a lot of times, jury trials are a vehicle to slow down the process of eviction because eviction cases are summary by nature. By law, they happen quickly.
Hmm.
So when you have a jury trial demand, which almost every case has a jury trial demand, no matter whether there is intended to be a jury trial or not, you
Yeah.
just demand it to
Yeah.
reserve your right. And that puts a huge brake on the proceedings, and it makes the landlord think twice. I have to pay my attorney a lot of money. A lot of time is going to be wasted. Why don't I just pay the other side to leave my property or give him a great deal so I don't have to go through paying my own attorney? So jury trials could be very expensive. Sometimes they go through with it, but courts are very, very busy. They don't want jury trials, so they will do whatever it takes for the sides to settle.
And
But
is the process is
yes,
the process kind of jury selection similar to
yes,
okay? My God, yes, I
it's
know.
exactly the same. It doesn't matter if it's a and here's the other thing. When you have a jury pool in the city of Los Angeles, you're going to have a lot of people who are renters who may have been screwed by landlords and they didn't get their window fixed or their lock is still not working. So there is a more sympathetic ear to be had in a jury trial. So it's all tactics and it's working. It's working for tenant rights groups.
Yeah. Yeah, it's ridiculous how that's one part we still have not figured out. And the fact of the matter is that it is, like you said, is a delayed tactic. It's a delayed vehicle. And I cannot believe until today we're allowing this to happen. I'm going to jump right in, and I want to make sure because I can imagine most of the people that are tuning in right now are on the landlord side. So I know, over the years, over the last 30 years, I've been doing this similar to you. You look a lot younger than I do, but for the last 30 years that I've been doing this, Ray, I've made a lot of mistakes. Okay, I've learned a ton, whether it's through property ownership or tenants and dealing with tenants, et cetera, et cetera. And I still continue to make mistakes, not trust my gut when it comes to a tenant. What are some of the common mistakes that you're seeing today that landlords are making? What would you say is like the top three or four to avoid, especially when it comes to, and this is kind of, in my opinion, is the most important part, are the notices, in particular the 3-day notices. What are some of the mistakes that landlords are making nowadays?
Yes. So one of the mistakes that would be landlords. So I'm going to go back a little bit, couple steps
Mhm.
before you're a landlord. When you are with your agent and you're looking at properties, I find that sometimes agents skip some steps. And I think a good agent who wants a client base who is going to keep coming back to them is
Mhm.
going to want an educated would-be landlord, especially the first-time landlords. So the first mistake I would say is not having your client or the would-be landlord go to a professional
Mhm.
and get some background information about what is it I'm buying. After all, it's millions of dollars at stake. And if it's sort of like you buy a used car. You used to, I don't know, back in the day, you used
Mhm.
to take a car mechanic with you to go see a used car. Hey, let's open up the hood and see what's inside. Is there oil leaking? Is there, is there a funny noise coming from the engine? That type of thing. So you want that first before you close the deal. You want to have a consultation with a professional, an attorney who does this all the time,
Yeah.
and say, hey, this is what I'm thinking. So sort of get a background of what is it I'm getting into. A lot of times the mistakes that I see is that escrow is closed, client has a bunch of papers, some not filled out correctly, estoppel certificates that are not signed, leases that don't make sense.
Yeah.
And then it's like, oh my God, now we got to reinvent everything and bring everything together. And sometimes, these landlords, new landlords, are upset. Oh, I wasn't told this by my agent. I wasn't told this by people I trusted. So
Yeah.
I think that's one of the mistakes of not getting the whole picture. What is it you're buying?
Yeah.
I think that's the first thing that you have to.
Yeah.
But I would say in terms of notices and things like that, it depends on the jurisdiction you're buying it.
Okay.
Okay, so I take out my old trusty Thomas guide, and see where the lines of the jurisdictions are. Sometimes it's LA County unincorporated. Sometimes it's the city of Pasadena, and what you think is Pasadena is unincorporated, and so on and so forth.
Yeah.
So all of these things make differences about what kind of notices to give.
Yeah, I'm sorry, I'm being interrupted by my entire transaction team and all of our offices at John Hart celebrating and throwing confetti all over the place when you mention estoppels, because we are in a transaction. You have no idea. We're the bad guy when we request these estoppel certificates. And to your point, and everybody that's listening, I don't care if you're getting the deal of a lifetime and you're buying at pennies on a dollar, you don't have your tenants fill out estoppel certificates, you are going to suffer the consequences. I'd made the mistake a year and a half ago, and until today, I'm suffering the consequences. As a matter of fact, you're dealing with it right now for me, a building that I own in LA, where I didn't get the estoppel certificates filled out because I bought it on the auction blocks. And until today, I don't know how much the tenants are paying as far as rent goes, what their amounts are. So I can't, and they haven't paid in years, and I can't do anything about it. So if there is one thing that you're going to learn from this conversation with Ray today, if you're buying a property, make sure number one, you're educated, you understand, you hire the right professional because this is so important. And number two, those estoppel certificates are collected, no ifs, ands, or buts. Ray, legal causes for eviction. I know there is a ton, okay? But give me like your top five. Smoking,
Yes.
excessive noise,
Yeah.
unauthorized occupants, what type of lease violations, cause, right? Because there's
Yes.
just cause and explain to me the difference between the two, and then also tell me what are the top reasons why a tenant has the right to, a landlord has the right to evict the tenant.
Yes. So let me just explain to you, hopefully, we can look at a spectrum.
Mm,
On one side is no fault. I'm
mm,
sorry. Yeah, no fault, no fault, no cause is on one side of the spectrum. No fault, no cause means the tenant did not have any fault in
mm,
any of this, and there's no reason to
mm,
evict. So that is the easiest way to evict someone. No fault, no cause, meaning you don't have a lease. I'm giving you, let's say, 30-day notice or a 60-day notice or a 90-day notice, and I want you to leave. I'm not giving you a reason, and it's not your fault. Just goodbye. I want you gone.
mm,
Okay.
mm,
Sort of like a commercial property.
mm.
Okay. Um, those are almost non-existent in the state of California, with very few exceptions.
Yeah.
No fault, no cause.
Yeah.
The other side of the spectrum is with fault, with cause. So, what are the faults of the tenant? Non-payment of rent is a fault. Breach of contract is a fault. Maybe they're not parking their vehicles in the garage. They're parking the driveway. They're in the way of other tenants. Or it could be that they are storing a bunch of junk in common areas. Those are the kinds of breach of contract cases. Or it could be just a nuisance. The parties all night until 3 a.m. This is excessive. Other tenants are complaining, or there's like a threat of violence against another person on the property. Those are the nuisance ones. So non-payment of rent is the most common. I would say probably 80% are that. Then you've got breach of contract. You've got nuisance. Those are fault of the tenant, and
Mhm.
it's obviously cause. So that's the other side of the spectrum. Okay. Obviously, you can evict for that. Okay. The middle part of the spectrum is no fault with cause, meaning the tenant has no fault, but there's a reason that you can evict.
Mhm.
Okay. And that is, for example, I want to move in a family member, a close family member. It's not fault of the tenant that I want to bring in a family member, but it is a cause recognized by state of California, by many jurisdictions in the county of Los Angeles. Now, if I do that, most of the time I need to go through an administrative process, for
Mhm.
example.
Mhm.
Okay. So I have the reason, it's not fault of the tenant, but I have to go through an administrative process and perhaps even pay a relocation fee to a tenant to move. Okay. So some examples in the city of LA are, you're moving in a family member, or it's an illegal garage. Let's say I just find out that, oh my God, this unit that I have this tenant living in is illegal. And then you get an order to comply from the city saying you gotta like stop using this garage as a living space. That is a reason that I can evict, but I have to pay and go through an eviction, I'm sorry, a relocation process.
Mhm.
So that's sort of like the middle of the spectrum.
Is there any proof that's required when you've got a move-in family member type of eviction? Do you have to show proof? Obviously, you have to file, but what kind of proof do you have to show in order for you to move in a tenant to move in a family member and evict the tenant?
So different jurisdictions have different laws, and that's one of the overriding themes of this discussion we're having,
Yeah.
that every jurisdiction there is a patchwork of laws. So you've got the city's laws, you have the county's laws, and then you have the state's laws. And you follow the one most restrictive
Yeah.
of the landlord. Okay,
Yeah.
that's the one you follow.
Yeah.
So, in terms in the city of LA, you go through a process. So you have to file some applications, some declarations under oath that you're going to have a family member move in and what their relationship is. So you file that with the city. The city then says, "Great," stamps your papers, and then you serve those papers along with the 60-day notice to vacate on the tenant, and then you also either give him a check, cut him a check for the relocation fees,
Mhm.
or you set up an escrow account of how they can get the money.
Yeah.
And so that's a process that you have to go through in order to do that. Now, I know a lot of landlords say, "Oh, I'm going to move somebody in," but they don't have the intention of that person living there.
Mm.
So you have to be very careful that this is not just a reason that your client is using to get a low-paying tenant out, because if they're found out that the family member never moved in and they're renting the property to just a stranger and collecting rent, there could be huge consequences and could be hundreds of thousands of dollars of a lawsuit coming their way.
Yeah, I want to make sure that, and I have a saying here, and I know that it's very common in law. Goes something like, your most restrictive restriction restricts, right? So as long as, and like you said, there are so many different jurisdictions, there are so many different rules and regulations and laws. But one thing that you can count on is if your city or your county is more restrictive than the state, then that governs. So just be careful with what rule you follow. And like Ray said, there's absolutely zero chance that I'm going to be able to ask you, even if you had all day, Ray. I'm going to be able to ask you every single question in every single city in every single county. This is just for those of you guys who are asking very specific questions. This is simply to get an introduction to Ray, to give you an overall sense of exactly what the new rules are, the new regulations are. And then if you have specific questions, obviously you can reach out to him directly. And if you want to use a vehicle like an agent or me or whatever, you're more than welcome to. I'm going to jump into something that I feel and I was gonna wait until the end for this, but I wanna get into rent caps as well as credit reporting. Okay. And I'm gonna start out with credit reporting first, even though I was going to wait until the very end because I'm baffled, right? Because I now have not only all the different things that we have to do as far as abide by law, but now we have to report as far as credit goes to for payment of rent that is made on time. Okay. Um, and first things first, for those of you guys who don't know, I think it's if I'm not mistaken, it's AB 2747 that basically says that now any landlord that owns 15 properties or more, or and correct me if I'm wrong, Ray, or has the property purchased under a corporation has got to report payment of rents that are made on time. My first question is, can I report it if they're delinquent?
I wouldn't. I wouldn't.
Okay.
One of the things that I have learned is it's not worth it. It's not worth because it used to be that we had agreements with whenever we evicted a tenant and we had an agreement, a
Mm,
stipulation in court that with the lawyer for the tenant and about reporting.
mhm.
I would stay away from the good or the bad. I would just do a neutral one.
Got it.
So I always stay away from bad reporting. Now the good reporting now is a law, okay,
Mhm.
for certain like you said, certain landlords who own a lot of property or more property, then I think it's like however many units. If you own more than 15,
Yeah.
again, this is part of the CAR forms. Some of the also some of the leases have
Mhm.
these boxes that you have to mark, and it explains exactly what's going on. And I think you can charge up to a certain number, like $10 or
Yeah.
something.
Yep. Yep. Yeah, it
You know,
is
so so
$10.
it's a some landlords like it
Mhm.
because landlords are like, oh, it's like students in a classroom who are getting the gold star.
Mhm.
Okay. It makes them somehow want to pay rent on time because they're getting that validation.
Mhm.
Okay. Some of my landlord clients love it.
Mhm.
They like to report the good. Now you have to, if you're a certain landlord.
Mhm.
But that part of it, yes, it's always good to praise good behavior. And I think it builds confidence. It builds a good rapport, a landlord and tenant. And I think that overall, this could be a positive, even though it's extra
Yeah.
administrative costs.
Yeah, that's my qualm with it. It's the extra work that needs to be done. But that only time will tell to see if this is something that's going to help us or hurt us. Definitely. Ray, do you mind if we jump into rent caps? And I know this is like a box that neither of us want to open, but we've got to get into it, okay? Because there's going to be a lot of follow-up questions to how much. But tell me, first things first, in LA City, what's the rent cap? How often can we raise rents on tenants? Is there a restriction right now as far as how much we can raise rents in the city of LA? And then if you can also give me some adjacent cities like Glendale, Burbank, and most of our clients right now that are tuning in, I think, are tuning in from LA County. So rent cap, CPI, if you don't mind, just
Yeah.
opening up this topic with just an understanding overall of exactly how much we can raise rents and how often.
Well, almost always it's once per year.
Okay.
Wherever you are,
Okay.
California, you're following the California AB 1482, or you're following a smaller jurisdiction rent cap law. Uh, in the city of LA, it's right now 4% per year.
Okay.
Now, every July 1st, we get a new amount published by the LA Housing Department.
Okay.
So we will know in the next month and a half or so. Usually it's in June, how much the July 1st rent increase could be for the city of LA. Now the fires did affect some of this. There were some movement in trying to get rid of the rent increase in the city of LA or even the county of LA. And what happened is it could be a defense to a non-payment of rent or rent increase. In other words, if the tenant proves that they were affected by the fires, then they can perhaps use that as a defense and not get evicted for non-payment of rent or rent increase notice. But the burden is on the tenant to prove that.
Mm.
So for the most part, I tell my landlord clients that you can increase the rent right now in the city of LA. In the county of LA, it's different. There are unincorporated areas of LA County within even Glendale area, parts of Montrose, parts of La Crescenta, Altadena. These are some areas that fall under the LA County ordinance. So you have to be careful about which formula you are using. But all of this information is available online.
Mm.
They're very user friendly.
Yep.
And I would urge everyone to acclimate themselves about different jurisdiction. City of LA is right now 4%. I can say in Glendale has the most, every time I look at the city of Glendale, ordinance, it makes me think I'm in law school.
Mm.
If not this, then this. You have to like. There's a lot of, but it's three or more units. You're at 7%, unless if you want to go over that amount, then you have to offer them relocation. There are certain guidelines in the city of Glendale that you have to also follow.
Yeah.
If you own property that is more than so many units.
Yeah.
Burbank doesn't have rent control right now, but there are certain laws as they pertain to economic displacement. If you're raising the rent more than a certain amount, and economically the tenant cannot afford it, they can ask for relocation fees to move.
Mhm.
So again, it's a case by case basis, jurisdiction by jurisdiction basis, but for the most part, the local laws govern. Now, the rent cap in the state of California is CPI plus 5%, but in no event could it be more than 10%.
Yeah. Yeah.
So a couple of years ago, we had high inflation and CPI was, let's say, 7 or 8%, plus five, that makes it 13, but you couldn't raise the rent 13, it would come back to 10.
Yeah.
So right now, we're looking at somewhere in the neighborhood of 8.8 or 8.9% increase in the state of California if there is no local um, rent control law that governs,
Yeah.
then you go to the state of California as a stopgap.
Yeah. Let's go into security deposits because I know a ton has changed for security deposits and how much you can take, how much you can collect, pet deposits, et cetera, et cetera. Okay, so first things first, what's the maximum number of months that you can collect as far as
Yeah,
security?
1 month. Now it's 1 month.
Okay.
One
What
month
about if
in the
what about
state
if
of
my property
California.
is furnished?
Doesn't matter anymore. There used to be a difference. Now there is no difference.
Okay. Uh,
So that's it.
what if there's a pet? Can I charge a security deposit if there's a pet?
Yeah, that's a good question. I'm not sure about that
Yeah.
because there is a movement right now.
Mhm.
There's laws going through the legislature that you cannot discriminate against someone for having a pet.
Yeah.
So the no pet policy and things like that are going to come. That's the next wave of things that are going to come down.
Yeah.
In my opinion. I stopped taking, there's a pet. I want to get rid of my tenant because there's a chihuahua in the
Yeah.
property.
Yeah.
I got out of that because it doesn't pass the smell test.
Yeah.
So the only time you should evict, in my opinion,
Yeah.
for a pet is that if that pet is dangerous or is a nuisance.
Yeah.
So if there's been a attack occurring or they're barking all the time, those are the kinds of things that I would say I would tell landlords to go after. Not,
Okay.
they have a small pet or something on the
Yeah.
property.
So there's a few, and it's very, very confusing as far as what they're doing with pets. I know that they're saying you can't charge an extra security deposit if there's a pet. You can charge extra rent if there is a pet. But it's really funny. Then, like to your point, it gets really dicey because if the pet is registered as a service animal, then they're not considered a pet. It's done, right? So you got to be very careful. Like Ray said, it gets dicey, and make sure that you understand exactly what the restrictions are. There's a lot of questions that are coming up, but one that I just noticed popping up, as far as yes, Dikla, as far as a security deposit is concerned, if you're a small landlord, and a small landlord is
Yes,
defined
yes,
as
yes,
as
yes.
four as four units or less, only two properties with 4 units or less. So that means if you have one property that has 3 units, you can't have the other property that has 2 units that's considered over 4 units. You can collect 2 months
That
of
is correct.
deposits. Okay,
There are,
so
yeah, like I said earlier, there are so many exceptions to the
unbelievable.
exception
Yeah,
that you just have to be you have to constantly have a cheat sheet.
yeah.
And then just when you think you've got it figured out, the laws change.
Yeah, I've seen those keyboard mats for Excel, where there's all of these Excel functions and control this, control that. I feel like we should make one for for landlord tenant rights these days. That's a pretty good idea, by the way. Maybe you and I should think about collaborating and building one
Yeah,
of.
but as soon as it's done,
Yeah,
something
exactly.
is going to change.
Exactly. It's like, but that's even better because now we get to sell one every month. Um, um, Ray, I want to get into, and I know that we're limited on time, but I do want to get into the some of the new restrictions as far as fair housing and tenant denials. Okay, because this is one thing that keeps me up at night with having the amount of agents that we have and the amount of properties and the different types of cultures and everything else, especially with right now ADUs. I am terrified when it comes to discrimination, when it comes to fair housing, how you're able to deny, for what reasons you're able to deny applicants. So let's discuss first the surface level stuff. Can I deny an applicant for any reason? Number one,
For any reason.
any reason.
Well, you have to be careful
Mhm.
that obviously if the person has really bad credit,
Mhm.
you can deny them on bad credit.
Okay.
One thing that I've seen lately is texts. I don't know if you and I have talked about this, but um, landlords are getting texts that say, "I saw your ad. Do you accept Section 8 applicants?"
Mhm.
Okay, and landlord says no.
Mhm.
Right there, that's discrimination.
Done.
And they fall into the trap and they get a lawsuit.
Yeah.
Okay.
Yeah.
So that's a trend I am seeing. It's sort of like those handicap cases, there's no handicap space in this shopping center or something, and I just send a letter out, or there's no ramp or something.
Yeah.
That's the kind of um, egregious type of behavior I'm seeing. So source of income, which you cannot discriminate based on source of income, whether
Mhm.
the person is getting aid from the government or not. You can't discriminate on that. I say the best thing is just to say, give me an application, fill out an application.
Yeah.
Okay, no matter who it is. Don't say yes, no, uh, nothing. Don't admit to anything, especially in a text, on an unsolicited text.
Mhm.
So you have to be careful.
Yeah. How do you deny? How do you recommend we deny? So, for example, if it's based on credit and we don't want to, and if they have bad credit, not enough income, and again, I want to preface this by saying not enough income doesn't mean what Ray said as far as a type of income. But if someone's making $3,000 a month and the rental is $4,000 a month, obviously you deny them for income. But Ray, what are your recommendations? Is there a specific rule as far as how we deny a tenant or an applicant for tenancy?
There is software available. I recommend my clients, I know a lot of my clients use the Apartment Owners Association
Mm,
for their credit reporting, and they have special software for denial, like
yeah,
a form letter. And
yeah,
I think those are great. You let the professionals do it versus somebody who's not in the business all the time.
yeah,
So you let property managers do it. You
yeah,
let special property management software do it.
yeah,
I think that that's the best kind of, instead of trying to figure out your own response, it's better to let the professionals do it. And I think that's the overriding theme in this 1 hour. You let professionals do the job. You let, whoever's good at what they're doing, you let them do the job.
yeah. It's so critical. It is so critical. As far as obviously move in and move out is concerned, okay. I know there's a lot of new laws now. Would you mind if it's something that you've gotten yourself versed with? I know the laws just changed a few weeks ago, but tell me a little bit about the move in and move out process as far as how to document photos, and if the tenant is moving out. And I also have a bunch of follow-up questions as far as move out goes on a 1 year lease. But first things first, move in, move out, photos, documentation. Can you give me the overall
Yeah,
picture
definitely. There's a
required?
checklist.
Mhm,
I have a checklist, for example, that I have my landlords use on the move-in,
mhm.
and it's signed by the tenant who is moving in about conditions of all of they have a couple of pages of conditions, and they mark whatever is missing or is satisfactory, and they sign it so you can compare the move-in with the move-out,
Yeah,
and that helps a lot.
yeah.
So I would say document, document, document.
Yeah. And I don't know,
Um,
Ray, if this is for us as realtors, as far as the National Association of Realtors goes. I have to look at it again, or it's overall in California. But as of April 1st, we're required to document any move out with any move in with photos and any move out with photos as well as of July 1st. And
yes.
it has to be, like you said, it has to be acknowledged by the tenant. Now, two questions following up to that. Number one, if I've got a 1 year lease, okay, and I always joke, there's no such thing as a lease anymore when it comes to tenant. It never expires. It's whenever they deem that it's going to expire because they're in control. But if I've got a 1 year lease with a tenant, my it's from April 22nd, 2024 to April 23rd, 2025. Am I safe to assume that if I don't renew that lease on April 24th, 2025, that now they're moving out?
Probably. Well, the option is with the tenant
Yeah.
if they're going to move out or not with the landlord. Now, again, jurisdiction matters,
Mhm.
type of property matters, when that property was built matters. So there's so many different factors,
Yeah.
and literally you could have one property next to another and they have different sets of laws,
Yeah.
okay, which is crazy.
Yeah.
But for the most part, you have to assume that no, the it's going to become a month to month. It's going to turn into a month to month, and you're not going to be able to have the tenant leave unless, again, unless under certain conditions. Now, in the state of California, those AB 1482 protections only attach if it's been over a year. The tenancy is over a year.
Mhm.
So I don't suggest a 1 year lease anymore. I suggest less than a 1 year lease because you don't want those protections attaching at the end of the year because they've been there a year. Okay.
Yeah.
So if you want to make up your mind, do I want this tenant or not? So maybe a month-to-month tenancy is better.
Mm,
Of course, a lot of tenants shy away from a month-to-month tenancy,
mm.
or maybe a 6 month one,
Yeah.
something that's less than 1 year.
Yeah. City of LA, it goes from 12 months to 6 months as well. It's nuts how different, like you said, you keep bringing that up. Different cities, different jurisdictions, different laws. Nobody.
And here's the other thing, Harut. I sorry that
Yeah,
I'm
no, it's
cutting
okay.
you off, but there is there are two sets in the city of LA. There are two sets of designations. There's the rent control properties that are called RSO, stabilization ordinance properties. There's a new designation as of a couple of years ago called JCO,
Okay.
just cause ordinance
Okay.
properties. So a lot of landlords in the city of LA are going to start getting notices that their properties are under the JCO.
Mm,
So all these years they thought that they owned property under that was not subject to the RSO, such as single family homes, condos and townhouses,
mm,
newer properties. They, they were happy about it. RSO doesn't apply. Well, now JCO applies. And for JCO, there's a whole different set of protections for the tenants.
mm.
And JCOs now are going to start having to register as of January 1st, 2025.
Yeah.
So a lot of the landlords in single family homes are going to start seeing JCO registration requirements, and they have to pay something like $31.05 per year. You're going to start seeing that. So before I forget, I wanted to, remind everyone that, they may have clients or themselves getting these JCO registration notices.
When you want to register for exemption, what is the best course of action? Should they just go do it themselves, or should they come talk to you about it? How,
No, online.
okay.
Online is the best. So I would urge everyone who either lives in the city of LA or does business in the city of LA to open up an Angelino account.
Mhm.
Just Google Angelino account. You can, username and password, and then you can conduct your business with the city, such as with the housing department. You can pay all your fees through this Angelino account. You can get your registration certificates through the Angelino account. It's a very convenient way than having to wait for the mail to come and go, and it's taking forever. Reporting of rent control properties on the website with this Angelino account is the best way, I would say.
Yeah, it's one of the most important things you can do. If you're a landlord and your property manager or your agent or whoever hasn't recommended to you to create this Angelino account, you're missing a huge or dodging a big bullet right now, because if you haven't been pinched by the city of LA for not paying or registering yourself as a landlord, you're going to. So just be very careful and make sure that if you haven't registered as an Angelino with the Angelino account, you do so immediately. Ray, move out. Again, I'm gonna go back to move out because I really want to
Sure,
make sure
sure.
that everybody understands what they should do as far as security deposit is concerned. Okay.
I would recommend a walkthrough
Yeah.
first, a
So
walkthrough.
they do. So how and when? When do you recommend they do the walkthrough?
I would say 2 weeks before they move out, within 2 weeks, because you want to give the tenant ample time to correct any damage or fix any damage that you're going to take out of the secure deposit. You want to give them that option. Okay. And I would document everything. I would take photos, before and after photos.
Yeah.
You want to make sure, like now it's a requirement, as you said earlier, Harut. It's a requirement. So I would definitely take photos. And remember, there's a 21-day window after they move out where you have to send the accounting.
Yeah.
So sometimes my landlord clients say, well, I don't have enough time. That's not enough time. I have to get somebody to come and visit. You can send a preliminary one to be supplemented later with an actual estimate, but at least get that accounting out. If you have to say TBD, to be determined, go ahead and do that, and then supplement it once it's done. I get a lot of phone calls from tenants too who say, "Oh, I'm asking for my security deposit. It's not coming. It's strange." I always tell them, talk to your landlord, and try to resolve it. It's only a few $100s. You should be able to resolve it. You don't want to waste too much time.
It's that part is probably the easiest part of being a landlord, is giving back the security deposit. And one thing that I always that's very common is that landlords screw up how to give back the security deposit, because they don't understand that a final walkthrough 2 weeks before, like you recommended, and then doing an accounting of exactly what it is that you're removing from the security deposit is critical. Wear and tear, because I know that a landlord, Ray, cannot deduct for wear and tear. What is considered wear and tear? What are the things that we should take into consideration when we're deducting for something that they either maliciously did, or something that I need to now repair because something that they did when they were living in the property? What's wear and tear?
I would say wear and tear is, you know, uh, let's say there's scuff marks in the wall,
Hmm.
okay, on the door, for example. It's like I always say, it's in the eye of the beholder.
Yeah.
What looks, obviously, if a tenant has lived in a property, let's say 10 years, it's not
Mhm.
going to look like day one when they moved in,
Yeah.
okay? So they're allowed wear and tear. Um, Damage for me is like holes in the wall. If they put up photos, and they've obviously put holes in the wall. I
Mhm.
don't think that's wear and tear. I think that's the responsibility of the tenant.
Yeah.
You have maybe, if they had a pet, their stains on the carpet, stains on the hardwood floor.
Yeah.
If there's obvious, ripping out of sockets. Again, it's in the eye if something is deliberate, and something was the property was not taken care of.
Yeah. It's in the smell test for me is anything that is discoloration is wear and tear, right?
Yes.
So if you go into, and I think also one of the things that I always take into consideration is how long they've been a tenant. Okay. If they've been a tenant for a few years, and the paint is now kind of discolored, then that's wear and tear. If they've maliciously gone in and they have a kid that's taken a crayon to the
Yes.
walls, then that's not considered wear and tear. So yes, it's very subjective, and that's one thing I hate about some of these things, is like, it's like you said, it's in the eye of the beholder. But definitely something that you should, if there's a doubt, forget about it. It's not worth deducting from the security deposit and going through the headache of can they can I deduct non-payment of rent from a security deposit, Ray?
Yes.
Okay.
Yes.
All right, good.
A lot of times there is that.
Yeah.
There is also, they haven't given the landlord sufficient notice that they're going to move out. They
Yeah.
haven't given the full 30 days notice as required.
Yeah.
Sometimes they say, I'm leaving in 5 days.
Yeah.
Okay.
Yeah.
Um, they can be dinged for the 25 additional days,
Yeah.
prorated, because they didn't give sufficient notice. So definitely, non-payment of rent can be deducted from security deposit.
Yeah. Yeah. So, Ray, so we've got at least about 100 120 questions that are up in the chat. Okay. And I want to be very mindful of your time. Just so you guys know, Ray is in the middle of trial right now. And he did take out an hour of his day today to have a conversation with us. Ray, I'm going to tell you. So this is what I'm going to do. Two things. One, I'm going to put this interview up on our YouTube channel. And then the second thing I'm going to do is I'm going to answer all of the questions in the comments of that channel. Okay. And obviously, Ray, anything that is pertaining to you and legal related, I'm going to ask you to answer. We'll go ahead and answer them in the chat or in the comment section of the YouTube channel, or the interview video. And then they can look at it there, because it's impossible for me to be able to answer all the questions right now, for you to be able to answer all the questions right now. But one thing I will do is I'm going to put up all the links to different things that you spoke about, as far as the HUD, Angelino registration, et cetera, et cetera, et cetera. All of that will be sent out to everybody that's registered for this. But I will tell you, Ray, and tell me, a closing thought on all of this, because
Yes.
I'm so determined to get all of our clients to really realize that this is not worth it. Okay, I'm a real estate guy. Please don't misunderstand me. My sweater really literally says invest with me, right? And I want everybody and anybody that is listening to us to really understand the wealth that's created through real estate. Okay. However, in California, owning anything that is considered SFR, for me, I'm no longer recommending, because it's not worth the pain. The pleasure is not even anything considerably close to the pain that we experience by being landlords. And I'm trying to transition everybody from being a single family residence owner, condo, et cetera, and getting them to understand that it's commercial is where it's at. What's some closing thoughts? What do you think about all of this? Should someone who owns a home rent it out to a tenant?
So, my thought on that is, I'm not as pessimistic as you are, Harut, even though my life is seeing the worst come through my door, right? The good things never come through my door,
Yeah,
only the bad. I only see the bad. I only see the problems, right? But I can tell you that one of the things that I see is when a person says, you know what, this property, it's like an 8 unit that I was going to buy. I'm not going to do it. It's just too much headache after talking to you. I just don't want to deal with it. There's a line of people behind them that are willing to do it.
yep,
That's the crazy thing, you
yep,
know? And I don't know where that thought comes from. It could be that long-term strategy of building equity. There's always going to be demand for real estate.
yeah,
So so maybe that's I'm not an investor. I'm not in your field. I love what you guys do,
mhm,
because you really give people the dream of ownership,
yeah,
and that dream of ownership sometimes doesn't have a dollar
yeah,
figure attached to it,
yeah,
and they love the fact that you know that they own real estate in the city or the state. But my thoughts are that if you are an educated owner, you can make it work,
yeah,
but it's a full-time job. It's not something, either you got to get a management company to do it for you, or you're going to be doing it, and you're not going to like those texts at midnight.
yeah,
You have to have a sort of a steel backbone.
yeah. And I want to explain myself, because again, I'm not a pessimist as much as I sound like one. And you're right. It is something that I've been very vocal about over the last couple of years, because I feel like California is doing a very good job of teaching tenants how not to make good on their promises, and a lot of tenants are listening to them. So that's kind of my qualm with this entire process, is just we're doing such a good job of making sure that landlords suffer the consequences of giving up their homes for rent to tenants. That's my issue, and that's why I'm really pushing our homeowners to reconsider renting out, especially if it's a single family residence, and taking that money and putting it into something like a shopping center or a small office building, or even their own business. But as far as if you are, and you're right, there's a line outside of our doors with people that are willing to throw their money into these kinds of properties. So there's always going to be the need for multifamily tenant housing, et cetera, et cetera. But if anybody does have single family, I always say reconsider, think twice before you do. And if you are going to your point, hire a professional. Make sure that you go through a consultation with an attorney such as yourself or a real estate professional that really understands exactly the intricacies that are involved with this type of investment. Ray, if anybody needs to reach you directly, sir, I'll obviously put your information in the comments in the interview as well. But if anybody wants to reach you directly, where do they call you?
You should call me on my office number, which
Okay.
is 323-953-9494. 323-953-9494. So that is the number. I I rather talk to the client myself. I don't have a huge staff of people talking to landlords because the complications of the law are too great, and I want to be the one that explains everything. Sometimes I'm in court, I'm in trial, I have other things happening in my office. I do get back to everyone as soon as I can
Yeah.
within the day. So I think that there are a lot of people, good people, very professional people who need help,
Yeah.
and I guide them. Before we close, I do want to say that there's one misconception, and I wrote it down for myself earlier and I forgot to get to it. It's called cash for keys.
Mm,
Okay. A lot of landlords are under the mistaken belief that if they pay a tenant X number of dollars, the tenant has to take it and go.
mm,
Okay. That is not the case. It's a voluntary contract between landlord and tenant. The tenant can say, no, I don't want to take that money and leave. That, it's a two-sided contract. So that's one of the misconceptions that some landlords have is if I just write a check, they have to leave.
yeah. Yeah.
So I just want to make sure.
And never, ever, ever give them the cash before you get the keys. Okay, never ever,
Never.
because they can take that cash and still stay in there. It's called cash for keys, not cash before keys. Okay,
Yeah,
so so please
very good.
understand the difference. It'll save you so much time and headache. Ray, thank you very much. Everyone else, I do every other Saturday. Next Saturday, I'm doing another buyer seminar that is being done in Spanish this time around. So every other Saturday, we do a buyer's seminar where we get you guys to understand exactly how to buy in this market, why to buy in this market, programs, et cetera, being an investor in real estate. So I do this every other Saturday. The one that I'm doing next Saturday is being done in Spanish. If you want more information on a lot of these things that we always do, go to my Linktree / Harutk, HAROUTK, and you'll find a bunch of different things that we do pretty consistently, including the buyer seminars that I do every other Saturday. Ray, I'm going to put up all these questions that you answered, as well as all the questions that are in the chat. There's hundreds of questions in the chat that I'm going to put into the comments, and I'm probably going to ask for your answers as well. Thank you very much for doing this, man. I know how busy you are,
Thank you.
and everyone else. I'm a client of Ray's, so just so you know, I vouch for him, and the guy understands exactly what he's doing, and I benefit from his experience and his expertise. So if I do it, I think you guys should as well. So definitely reach out
Thank
to
you.
him if you have any more questions. Ray, appreciate you.
Thank you, Howard.
Everyone
Thank
else,
you, everyone.
thank you very much. Cheers.
Thank you. Thank you, John Hart. Thank you.